measure is whether immediately before the service provision change there is an organised group, and if this group has ceased to exist by immediately before the transfer, then TUPE will not apply, and therefore this may be a way for the client and contractor to come to a commercial agreement as payoff. So in terms of one of the most frequently asked questions, what does and does not transfer, is definitely at the top of the list. So identifying what does transfer with an employee. So their terms and conditions of employment, namely salary, sick pay hours, place of work, duties, continuous service, so essentially all the contractual elements that you will get in the due diligence information. The transferor's rights, powers, duties and liabilities, which namely are things like personal injury claims, tribunal claims, any ongoing disciplinary or grievance issues, any accrued debts that are owed to the employee, which you need to make sure are covered in the commercial indemnities agreed at the time between the two parties. So for example, a personal injury claim is covered under the employer's liability insurance, which the transferee would not have at the time it occurred. Therefore, the transferee needs to ensure the indemnity covers this from the transferor's insurance. Collective agreements transfer at the time of the transfer. However, but they only transfer as a snapshot of what was at the moment before the transfer. So for example, the term is static rather than the dynamic. So in the example of pay negotiations, anything negotiated after the point of transfer would not then apply to the transferred employee unless it was negotiated with the new employer. Trade union recognition will transfer if it retains operational control once transferred, which means it maintains an identity distinct from the remainder of the transferee's undertaking. In essence, it does not need their input for it to continue to govern itself, and will include having the power to independently organise work, give orders and allocate tasks to employees. If the undertaking is reorganised and fully integrated into the transferee's business on transfer, union recognition will not transfer. So the UK Border Agency requires transferees to carry out their own checks to avoid civil penalty within 28 days post-transfer, which includes the notification of change of sponsorship of employees. Certain pension provisions transfer, and the transferee is bound by a no detriment pension guarantee, so personal pension contributions and group pension schemes will transfer at the same rate. But the Beckham versus Martin cases are a note to point, because again commercial indemnity needs to be built into this, because early retirement clauses do not transfer, early retirement, and without access to the initial pension pot, then there is a risk of shortfall if no indemnity is agreed with the transferor. So moving on to what does transfer, rights, basically rights that did not exist at the time of transfer. So for example, in the case of Jackson versus Computer Share Investor Services PLC, Jackson claimed that she should be entitled to the enhanced redundancy rights that Computer Share had in place for existing employees when she transferred over to them, although she did not move on to their terms at the point of transfer. The tribunal ruled that she was not entitled to these enhanced terms for her subsequent redundancy, as she moved over on her own terms and could not pick and choose what terms and conditions she wanted. The responsibility for PAYE and national insurance on pre-transfer payments don't transfer, and this is another area that should be covered commercially in case there are any outstanding payments at transfer, because obviously the incoming contractor does not have liability for these. Criminal liabilities relating to transfer employees don't transfer, so things like health and safety claims. Liabilities arising after the transfer date. So, for example, the transferee is not required to take on a dismissed employee by the transferor unless the dismissal is connected to the transfer. And finally, occupational pension schemes and benefits for old age, invalidity or survivors don't transfer. So, for example, at 65 the pension scheme right will end, ill health retirement cannot be claimed, and there's no death in service benefits that transfer. So in many cases, the transferee will want to operate the business in a different location. However, the question is whether it can require employees to move to that location, and what happens if they do not wish to move. In answer, this will largely depend on the terms of employment of the transferring staff and the reasonableness of the move. So firstly, if employees have a geographical mobility clause in their contract that is enforceable in line with the changes proposed, then they can obviously choose to enforce that. However, if there is no geographical mobility clause, then the employer will need to consider each employee's personal situation and whether the proposed move will be of detriment to them and potentially warrant a redundancy situation. If the move is deemed reasonable and there is no material detriment, then the employer can look to consult and enforce if necessary. However, if not, then a redundancy consultation would need to be undertaken. A point to note on this is Regulation 4, Section 9, which provides that where the transfer involves a substantial change in working conditions to the material detriment of a transferring employee, such one can threat the contract as having been terminated and is deemed to have been dismissed. This is known as a quasi-constructive dismissal claim. So realistically, we need to remember that a happy employee never takes their case to a tribunal, so if they feel they have been treated fairly, there is less risk. So in the majority of cases, an employee wrongly assumes that if they decide not to transfer, they can be made redundant from their role with the transferor. However, a redundancy in this situation would be deemed automatically unfair, as there is no ETO reason and the same business continues to exist and operate, albeit in different hands. So at the point of transfer, that employee is deemed to have been terminated by operation of the law, i.e. they have chosen not to accept their rights to TUPE. Therefore, there is no dismissal or resignation, and they move and they have no right to any further payments after this point. A point to note, though, is that there may be genuine circumstances where a redundancy situation occurs and the employee is potentially entitled to redundancy. However, in relation to TUPE, this would always be from the incoming contractor and not the transferor. So a key question around TUPE is how long does a transferee have to wait before the risk of a dismissal is linked to the transfer? In answer, there is no fixed time limit, as in any case, regardless of whether a TUPE transfer has recently occurred, a dismissal is only fair if there is a valid rationale, i.e. an ETO reason, meaning economic, technical or organisational, for a redundancy, which considers a selection, consultation and alternative employment process. Case law does suggest, however, that tribunals require more than an economic, namely financial reason for a dismissal to be fair when there has been a TUPE transfer. In essence, it is suggesting that workforce numbers and/or employee functions need to change to mitigate the key rationale transferees try to use when they find the contract is not financially viable, given the burden of transferring staff. Tribunals will look at many factors when assessing whether a dismissal is fair, and closeness in time to a transfer would only be one, but would be disregarded if the rationale is sound. So the above table is a summary of what we have just covered, and as you can see, the key for any dismissal is that there is an ETO reason if it is related to the transfer, and if not, then normal rules for a fair rationale apply. So terms and conditions of employment are a key stumbling block to many transferees. As we are aware, what does transfer and assume we can amend and agree terms if need be. So the question, can the transferee introduce new terms and conditions, and if agreed in writing by all parties, are they legally binding? So generally, changes to contract following transfer will be void, even if the employee agrees to it in the case. So for example, in the case of Credit Suisse First Boston versus Lister, it was held that the employee was not bound by a restrictive covenant which had been entered into around the time of the transfer, even though when it was looked at as a whole, the employee was better off. In summary, this was because the term was of a detriment to him. You can look to make changes valid, however, if the change is not detrimental, i.e. on a term-by-term basis within the contract, as no negative terms can be enforceable and there is no trading off, for example, the buying out or trading off of terms. There is an ETO reason for the change and it is unconnected to the transfer. And finally, most importantly, the change is effected through a dismissal and re-engagement, although again this has to be in line with the previous terms and not the sole way, as it can still be unfair. And finally, moving through to the consultation process and both the transfer and transferee obligations, the key questions in most service provision changes is in the event of a small-scale transfer, is it sufficient for the transferor simply to inform and consult with individual employees rather than electing reps? The answer is no, as there is no legal requirement for consultation as there is a legal requirement for consultation to be entered into with the appropriate representatives of effective employees, these being trade unions where recognised, existing employee reps, or possibly both. However, if there isn't presently any in place, then you need to give the employees the opportunity to elect reps and remember to build in time for the necessary elections and training. If the employees fail to elect reps, then as an employer you can inform and consult direct. However, it is important to at least invite and have documented the fact you have given them the chance to elect reps. A point to note is that consulting with reps does not stop individuals' contact with employees, as the process should be as open and consultative as possible. So that's the end of the webinar. So you should now be able to evaluate whether TUPE applies, including outsourcing, understand the practical process for TUPE, and identify the impact of TUPE on dismissals and changing employee contracts and working practices. So in summary, the pack that goes with this webinar includes the slides, a frequently asked questions summary sheet, an overview of TUPE claims, TUPE commercial tips, and these will all be sent via email to the address given. And you should look out for more webinars from Rattan HR on the website that you can see there. And also, our new website outlines our full HR and health and service offering if you are interested in the services we do offer. And if you do have any further questions, which I did say at the beginning of the webinar, you can take advantage of our free trial and contact us on the number that you see on the slide there. So thanks for joining me for this webinar today, and I hope you enjoyed it and you enjoy the material that you'll be